What is up, people of the interwebs? It's me, John Crump, broadcasting from my Delaware studio. I see Goomy, drop it like it's Scott out there. Jay, Minuteman for Jesus, shooting galleries out there, Poor Man Machine Gun, B-Lim, and others out there. Today we are going to be listening to a case being heard in the uh, Fifth Circuit Court of Appeals out in Texas in the en banc courtroom. It's not en banc, but it's in the en banc courtroom. There's a three-judge panel, and they are going to be hearing McRorey versus Garland. This is a lawsuit challenging a status of young adults. If you don't know, the Bipartisan Safety Communities Act, which was a huge gun control bill that passed with some Republicans like John Cornyn supporting it, established enhanced background checks for anyone under 21. If you went to buy a long gun, you have to go through an enhanced background checks. It makes it a big pain in the butt, and it takes a long time to get your guns. So they are infringing on the rights of people between the ages of 18 and 20. And this case is challenging it. It was brought by McRorey, a girl named. Oh, it's coming on now. So let me go ahead and share it. Stephen. They're having some technical difficulties.
When a young adult goes to purchase a firearm, emphatic no, is the Supreme Court held in Bruin that in order to be constitutional, regulations on the Second Amendment must be historically the government failed to demonstrate that this mandatory delay, which is only applicable to 18 to 20-year-olds, is grounded in this nation's history.
The Second Amendment doesn't mention buying.
Well, in order, and there are other ways to acquire an arm other than buying, but it seems like
So, in the Second Amendment, when it's talking about keeping and bearing.
Without being able to acquire a firearm, Your Honor, there's no keeping and bearing. The government would then be able to say, look what a marvelous Second Amendment loophole we found, that we can stop people from keeping and bearing simply because we can stop them from buying. Historically grounded, that's not in our tradition as a nation, where we've precluded people from purchasing firearms. Sure, there might be some on the fringes of being able to preclude them, but 18 to 20-year-olds are not allowed to be excluded from the people. They are part of the people, and therefore it's unconstitutional to make them wait an additional 3 to 10 days when NICS, the National Instant.
But aren't there other ways to buy besides going to the ones that are licensed by federal commercial?
That's a
Sure, they
plain
could go
judge.
to the secondary
Biden
market.
judge.
They could go buy a used firearm, right? But we're, our position.
So it's not. I mean, your brief made it sound like they just cannot get a gun, and that's not true. Even ignoring this 3 to 10 day situation, which is not a never. But can you address that? Why that isn't enough?
Sure. Well, that presumes that the government's entitled to tell us how to exercise our rights, and I submit to you that that's not historically grounded and that's not allowable. So, if to take a different hypothetical, if the government says, "Well, Mr. Stamblia, you have a free speech right, but you just can't post anything on Twitter," or "You have a free speech right, but you can only use Facebook to post anything online," I think the court might have an issue with that, and I don't think the Second Amendment is any different when we relegate young adults to the secondary market. Like, for instance, if Mr. McRorey wanted to buy a rifle that was in demand or something that wasn't available on the secondary market, the only opportunity he has to buy it is through an FFL. If he were to get on Gunbroker or one of the other sites, they would ship it to his FFL, and then at that point, even if it's a used firearm, he would still have to go through the mandatory delay and background check process. The only alternative would be for him to go to a friend that's willing to sell it to him, and then at that point he doesn't get to choose what type of firearm he's getting. He's just getting a firearm. So I don't think that's really an answer to say that well, he has the secondary market and he should be relegated to that.
Okay, let's assume arguendo the only way is going to one of these stores. Can you explain why the relatively short delay is unconstitutional?
Easily, Your Honor, because historically we have, pursuant to Brune, we have to check and do a historical analysis to see if the regulation is inconsistent with what the founders thought in 1791 that would apply. And the government, as the district court stated, I think it was record 300, the government failed to point to any specific founding era regulations that were like this regulation that they put on. And what it does is it treats young adults, 18 to 20-year-olds, differently than it treats someone like me that's 45 years old. So when I go to purchase a gun, I would get an instant background check. Well, they're not instant for the young adults. There's no historical tradition, and it's unconstitutional pursuant to Brune that requires us to go back and look at the nation's history and tradition.
Well, it's interesting because you just talked about the First Amendment on Facebook, and I doubt that the 1700s is going to explain Facebook to us. So things, while I very much understand what Brune is saying, and I very much respect that we follow what the Supreme Court says, things do evolve. And one of the arguments your opponent made is the evolution has been how you get a gun. There used to be, like, we'd make one a day and we knew everybody in the city or whatever. And so there wasn't this issue. Now, if you're wandering around New York, that's a lot of people, and they're making guns, a ton of them, in a short amount of time. So that wasn't the situation then. Sort of like Facebook, as far as I know. I wasn't there in the 1700s, but I don't think Facebook was either.
Well, I think that's judicially noticeable that it was not in existence in 1791. But
both sides agree on that.
But the Constitution endures for new technological advances. It does. And so they cite in their brief, it's like it's a new societal problem, right? But what is the societal problem? Is it gun violence? Well, Heller and Brune both spoke about gun violence. Justice Breyer in his dissent talked about how the handgun was the most favored weapon of the criminal. Great. Okay. Well, maybe that's so. And then the majority said that it's also the quintessential self-defense weapon. So if Justice Breyer's nod to the criminal misuse of a handgun, I don't want to say mattered because I think that's probably the wrong thing to say, but it didn't carry the day, obviously. So I don't think that we can look at, like Your Honor said, we have a lot of people, we don't know who everyone is. Well, NICS background checks, the same NICS background check they would run on me or any one of you that would go to buy a firearm is the same thing that they run on the 18 to 20-year-olds, plus they do extra things. So if—
And additional sources of information.
Yes, ma'am, that's correct. But
The initial delay is still for 3 days. The only time you get to the 10 days is if there's more investigation that needs to be done.
well, it's 3 business days to 10 business days. It's not calendar days, which I think is important because, as we know, life also happens on the weekends when the state offices are closed. So it could be 3 business days, but it could also be 5 calendar days, 6 calendar days. Hayden Haynes' affidavit that we submitted had 18 days before he was allowed to get his firearm. And I understand the other side's going to come up here and say, well, it's the FFL's prerogative if they want to transfer that firearm after 10 days, 10 business days to the purchaser if they have been delayed. But a lot of people in practice don't do that because the ATF, if that person is ultimately denied, the FFL is going to have to answer why they have this firearm going to someone that's been potentially denied.
But you can't trace those discretionary acts of those third parties back to this act.
Well, so I would go one step before that, Your Honor, if we disregard the acts of the third party. So in their brief, they said that we can't say that Ms. Flores would have gotten her gun that day. And then they put in their brief that, well, they have an affidavit from the FBI saying that Mr. McRorey passed a background check, Ms. Flores passed the background check. So I would submit to the court, on the day that Ms. Flores went to go buy her shotgun, she would have been able to, that day, through a NICS check, the same check that's run on me, be able to pick up her shotgun that day and not have to wait the 3 to 10 business days and not have some kind of miscommunication between the FBI and the FFL to where to this day she still doesn't have her gun. So I know that's probably an outlier case, but that's what's happened in this case.
Of course, we start with the proposition that the statute is presumptively lawful, and then we also have the acknowledgement in Bruin that background checks are okay under the Second Amendment.
So the district court and the FBI lean hard into Heller's dicta about commercial qualifications on the sale of arms and the background check in Bruin footnote 9 and in Kavanaugh's concurrence. However, I'd like to just reiterate to the court that that is for carry permits. That's not for acquiring a firearm. And the court might say, well, that's not really different. It's still background checks on a firearm. But we have to make sure the how and the why of the regulation match. So the how and why of Bruin footnote 9 is for carry permits, where a lot of those states don't actually require you to be licensed to carry. I know Louisiana is going permitless, I think, July 1st. Mississippi, where I'm from, has been permitless. Texas is going permitless. So I don't think that we can say just writ large that all background checks are constitutional. You'll notice in Bruin, they did not do a historical analysis on whether or not background checks are constitutional. Justice Kavanaugh didn't do it in his concurrence in Bruin footnote 9. Just basically said, you know, these could require a background check for carry permits, and we don't call into question the 43 states. So I would say they're asking for all background checks to be on. There's just a couple other points that I'd like to make.
What was the reason that there had to be an amendment to the Constitution to go from having to be 21 to vote to having to being allowed to be 18 and vote?
I'm not sure I understand the question. I'm sorry.
Well, you're saying 18 to 20-year-olds are like always the same, and my memory is not on voting. You had to be 21, and then they changed that to 18.
So I'm not saying that 18 to 20-year-olds are always the same. There is, I don't think, any question that they were defined.
If you go to the bar, you'll find out they ain't the same. But anyway, go ahead.
Well, what I'm saying is, if we look at historically what 18-year-olds to 20-year-olds were allowed to do, in the
The audio keeps on cutting out from the court side.
Considered, full adults until they were 21, the age of majority, and during that time period, doesn't mean that they didn't have the right to contract, get married, be enrolled in the militia, and to do all of the other things that we would normally consider, adult behavior. And there's no question now that 18 is the age of majority. I know they can't buy cigarettes and alcohol because they increased that age, but they can absolutely get married. They can absolutely change their gender, and they can absolutely join the military at 18. So I don't think that we should treat them differently simply due to their age and make them have to wait to exercise an enumerated right.
Well, I was trying to look back, because we're having to look back. If we were just looking at right now, I think it would be an easier case. It's a more difficult case for us to decide which way to go on this because of looking back. And even if I look elderly, I wasn't around in the 1700s, so it's a little harder to look back.
Well, and as Bruin said, the court is I'm gonna miss the quote out, but they decide on the case that's brought before them with the historical analysis has been done. It's not up to the court to sift the record to see the historical statutes. The district court held that the government basically didn't meet their burden, but leaned hard into the dicta of the commercial qualifications on the sale of arms and Bruin footnote 9 and upheld it on that. And again, the government has stated that, up to 200 people, 200 young adults have been denied their attempted purchase, but that doesn't mean that the law is constitutional. You can't have, if someone gets pulled over illegally, but the police find cocaine in the trunk, it doesn't constitutionalize the stop, right? So just because 200 people or thereabouts, and my friend can correct me if I'm wrong, doesn't mean that, well, this is a good law because we're not interest balancing. We have to go back to the founding. We have to go back and see, as Judge Jones did in the NRA v. ATF2 dissent from en banc, a historical analysis to see if this regulation comports with the Second Amendment, and we submit that it doesn't. Thank you.
Thank you, Mr. Stambouli. You've saved time for rebuttal.
Thank you.
Ms. Dixon?
Good morning, and may it please the court, Courtney Dixon for the government. Just a few points of clarification to start out. The NICS background check that applies to all adults for commercial sales allows investigators up to 3 business days to search for records. And after that point, as here, it's up to the discretion of the dealer if the background check isn't complete. The plaintiff's core theory in this case, in which they sought a preliminary injunction, a nationwide preliminary injunction to enjoin these provisions, is that any wait at all for a background check to be completed facially violates the Second Amendment. The district court correctly recognized that that would implicate any background check that the federal government is performing, and that it cannot be reconciled with the Supreme Court statements in Bruin. The Supreme Court said that nothing in its analysis was intended to suggest the unconstitutionality of shall issue provisions such as background check in circumstances in which they're put towards abusive ends. The district court correctly held that plaintiffs had made no such showing here. I'm happy to answer any questions that the court has specifically.
Well, do you want to respond to the conversation I had with your opponent? What is your response to the fact that the Second Amendment doesn't mention buying, but as he said, if that's going to get thrown out the door, well, then heck, it's going to be hard to keep and bear, isn't it?
Yeah, a few things to that. One, every time that the Supreme Court has canvassed the Second Amendment, both its text and its history, it is made clear that the right is not unlimited. In Heller, the Supreme Court, went out of its way to say it was not casting doubt on conditions and qualifications on the commercial sale of arms. This does apply only to commercial firearm sales from federally licensed dealers, and it's intended to respond to a uniquely modern problem, as your Honor's question suggested. Today, an individual can go to a big box store and have their pick of firearms and purchase them from a stranger who does not know them. Background checks, again, particularly these, which respond to commercial firearm sales, that particular transaction. That's what this is trying to address. The Supreme Court statements in Heller, the Supreme Court statements in Bruin, all again strongly suggest that plaintiff's core theory in this case, that they have a constitutional right to commercially purchase a firearm, instantly, which, plaintiffs don't define, and again, would implicate the NICS background checks that apply to all purchasers. The district court correctly rejected that argument.
Well, and I'm well aware of, what happened in Uvalde and so on and so forth. And that there are issues of, 18-year-olds going around shooting a bunch of people, but there's also issues of people in their 20s, 30s, 40s, 50s, 60s, 70s, whatever, shooting people. So it is not as if only the 18 to 20-year-olds are the people that are shooting a massive group of people. So why should we focus on them?
After the shootings in Uvalde, at the shootings in Buffalo, Congress got together on a bipartisan basis. They debated legislative proposals, and they, chose that one important step to better ensure that firearms are not sold to prohibited persons was to, with respect to under 21-year-old purchasers, this group that's disproportionately involved in violent crime, that, supplement the existing background check process to check 3 additional state sources for disqualifying juvenile justice and mental health records that would show that these individuals are prohibited under existing firearm prohibitions that plaintiffs do not challenge here. That was, again, the step Congress chose, bipartisan, to address this problem. Could they have gone further? Sure. I mean, this type of background check provision, again, plaintiffs do not have a constitutional right to commercially purchase a firearm instantly.
Is it your view, that the view of the Department of Justice, that we have to reach the historical analysis, or can you prevail without our reaching that analysis?
So at the threshold, the first question is whether plaintiff's intended course of conduct, is within the scope, the text of the Second Amendment. Bruin gave explicit guidance to courts and legislatures about, this question here, and that, at a minimum, strongly suggests the court does not believe that plaintiff's intended course of conduct is within the scope of the Second Amendment. I mean, the court, in Bruin, it was considering the proper cause requirement that licensees had to show a special need for self-defense over and above that of the general public to obtain a public carry license. The court said that prevented ordinary law-abiding individuals from exercising their right to licensing regimes of a majority of states that have objective requirements such as background checks that are intended only to ensure that firearms are kept only by law-abiding responsible citizens. And the court did not think that, at least on a general facial basis, whether plaintiff's course of conduct is within the scope of the Second Amendment. We have strong and compelling guidance from the Supreme Court very recently that no, the court does not think that it is. And, to put a finer point on it, Justices Kavanaugh and the Chief Justice in their concurrence referred to such provisions as constitutionally permissible.
Okay, but you're not arguing that if the Congress passed a rule that said you have to wait a year to get a gun, during which you have to keep saying every day that you haven't done anything wrong and so on and so forth, that might be a bit too much.
Yeah, I think that, again, the Supreme Court's language, it did not rule out constitutional challenges to such regimes where they're put towards
Like an abusive one.
right, and that's what your hypothetical suggests.
And so where is that cubby? I mean, I know that the Fourth Circuit one has gone en banc, but it felt like 30 days was too much. So what's the cubby on what becomes abusive versus what makes sense?
Right, so a few things. I mean, first, with respect to that provision, the court is considering that en banc. I'll just say that with that provision, it was a 30-day regime that applied to, any transfer, sale, gift, loan, and it also was a 30-day transfer before having another 7-day background check. And here, of course, 10 business days is quite shorter than that. I'll also say, it's not just the number of days, I think, in the abstract. I would emphasize several parts of this scheme in particular. I mean, first, at the outset, the statute directs investigators to immediately contact these 3 state sources for information. It says as soon as possible, but in no event more than 3 business days. Investigators have to get back with one of 3 responses: approved, denied, or a determination that cause exists for further investigation. And then it says as soon as possible, but in no event more than 10 business days. Again, you make the final determination. So at every step, this statute is directing investigators to act as soon as possible. There is no minimum weight, and plaintiffs refer to a minimum weight. There is not. If NICS gets the information that it needs, it'll transmit the response to the dealer. There's no reason to wait. There's no minimum waiting time. And so in this context, I think, absolutely, as the district court held, plaintiffs have just not made a showing that this falls into the kind of provision that Bruin thought would present a constitutional concern.
I'm sorry, so your answer to Judge Smith is, we don't have to get to the historic.
I think this court can answer it on the first step, yes.
All right, thank you, Ms. Dixon.
Thank you.
Mr. Stamalia for rebuttal.
Thank you, Your Honor. May I proceed? Thank you. I just have a couple of things to point out. Judge Haynes, I think you hit the nail on the head. If this is constitutional for 18 to 20-year-olds, as my friend here says that they can go further, then what is the limit? They're going to say, well, a year might be too long, or 30 days in the Fourth Circuit might be too long. I submit that Bruin is the limiting principle here. Bruin commands us to go back and look at the text, history, and tradition. And if the founders would not have allowed a 3 to 10 business day waiting period, then we shouldn't allow it either as a faithful application of Bruin. And I can demonstrate that using Bruin. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside of the Second Amendment's unqualified command. Now, my friends talked about, well, they could just go buy a gun from a stranger. And that seems bizarre because the whole purpose of the Bipartisan Safer Communities Act, as they stated, is to prevent felons and the mentally ill. Well, what kind of fit is that with the purpose to tell us to go buy guns from a stranger?
Well, I mean, we already have that issue that that commercial, licensed places, federally licensed places are not the only place you can get guns. That's already an issue, but that's not at issue here. And my understanding is you can discriminate against, I'm not saying under the Constitution, but I'm just saying we don't have discrimination rules under 40 for discriminating based on age. Of course, there's many other, when I said you can discriminate, I don't mean in general.
I understand.
I mean on the issue of age. So the fact that you can't go down to the bar if you're 20 here in New Orleans and have yourself a nice wine is not considered discrimination the way that firing somebody because they're 45 is discrimination in the U.S.
Well, it's presumptively discrimination too, but the employer can come back and
I'm firing you because you're 18, it would not be.
it would not be under the act per se discrimination. But going back to Your Honor's example about the age discrimination, it's presumptively unlawful, right? If you go in there and say that you're firing me because I'm 45, but you could also
40 and above is
that's right. So I mean,
not under 40, which 18 to 20 is under 40, as you will.
That's right. But if we're talking about these presumptive constitutional statutes in Bruin, or if we're talking about something that's presumptively constitutional, just because there's a presumption doesn't mean we can't rebut that presumption. So like in the Title VII context with McDonnell Douglas, the employee makes their prima facie case, finds that she has protected conduct, that she's been discriminated against, then the employer steps in and the burden shifts to him. And that's kind of how I see it. It's not a perfect example, but that's kind of how I see Bruin's requirement to get past the first prong and then go and do a historical analysis. If we take the Second Amendment, we have the people, and they did in the district court say that 18 to 20-year-olds don't have Second Amendment right. They've walked that back a lot in their appellate briefing where they don't really specifically make that claim. They kind of imply it. But courts around the country are holding this: 18 to 20-year-olds have Second Amendment rights. So Ethan and Kaylee are part of the people. And so then you had to say, is their conduct protected by the Second Amendment? And as I explained earlier, if they can't acquire guns, they cannot keep and bear. And there's a question, well, whether or not they can go buy it from a stranger. It seems to defeat the purpose of the act, which is to prevent guns from getting in the hands of the mentally ill and the felons. But I'd submit to you, Your Honor, Congress already has this system, this NICS system set up where any one of us can go in, assuming we're all over 21, we can all go in and immediately get our gun, almost like 95%.
Your opponent suggested otherwise on how immediate it is. It's just they're adding more places you have to look. Let me ask you one other thing quickly. Does it make a difference if historically the length of time that you're alive has changed and people's sort of timing as young has also sort of changed over the centuries, to where, you know, 45 is considered young, and I think 200 years ago, not so young.
Your Honor, I will admit I have not looked into that specific issue, so I really don't have an answer for you. Thank you very much.
Thank you, Mr. Stamboulin. Your case is under submission. Next case for today, Cope versus Coleman County.
All right, that was Stephen Stamboulin. Stephen Stamboulin is a good friend of the channel, who's been on the channel, known as Machine Gun Lawyer. He is one of the lawyers for Gun Owners of America. Him and Rob Olson wrote the briefs on this. Rob is also a good friend. We call him the Chicken Farmer. And Kaylee Flores, one of the plaintiffs, works for JM4 Tactical, which is a great company. And actually, I use their holsters. So go check them out, JM4 Tactical. When we were looking for plaintiffs, I said, "Hey, do you guys have any employees there that are under 21 that wants to buy a gun?" And Chad, the owner of JM4 Tactical, goes, "Yes, I do." And that's how we got Kaylee on the case. Ethan is also a good guy, and yeah, you can tell one judge was a Biden appointee. We already know the way that she is going to go. The lack of questions from the other two conservative judges is a good sign, though, because that shows that they probably already have their mind made up, and being conservatives, that's probably going to go our way. So that is a good sign. It's not going to be immediate. It's going to be a little while, probably a month or more, before we get a answer. Now, the next steps in the case is, either way, it's going to continue. If our side wins, the pro-gun side wins, I see the federal government, Garland, the DOJ, whoever, skipping the en banc process and probably going for a writ of certiorari to the Supreme Court, because in the Fifth Circuit we have a huge advantage on an en banc. Remember, in the Fifth Circuit, the bump stock case in Cargill, that was a 13-3 decision, and I think this is a slam dunk. And if we go en banc, now if we lose the panel, which I hope we don't, but we will definitely ask for an en banc from the entire bench, all 16 judges on the Fifth Circuit Court of Appeals, and I think we would have a good chance of winning that, a better than average chance winning that. If I was a betting man, which I'm not, I would go ahead and bet on that, but we'll have to see. I think Stephen did a bang up job. I think he did a great job. Yeah, it was a good case and a good argument. The government has no historical analogs to prove that the law is constitutional. And Bruin said, text, tradition, and history. Someone did bring up, I can't remember who it was, but somebody brought up how they leaned into the dicta. That is correct. Dicta doesn't have any legal standing, but it can be dangerous. That's why bad dicta is always dangerous in a court of law, because judges who wants to decide a certain way but don't have a legal standing to do so usually leans into dicta. So we'll have to see what happens there. With that, that is the case. I got another story I'm working on that should be out this afternoon. So that one's definitely going to be interesting, and definitely going to be interesting to all you guys. So keep an eye out for that. And with that, I think I'm going to go wrap it up here. But thank you for watching. And with that, we are gone. Thanks.